All right, so welcome back for our session on cooperative procurement. This is the session after lunch. And I know nobody had too much to eat, but please do your best to stay awake if you can, okay? In the past, we'll get started here in a moment, but in the past we've done some sessions on NASPO Value Point, which is the cooperative that is run by NASPO. It's NASPO's funding model. It's what allows us to do these conferences. But over the course of a number of years, and as we see more and more new attorneys coming to Law Institute, and we see changes throughout our internal processes, as well as greater reliance on cooperative procurements, we thought it would be informative and important that we try to make sure that everybody is familiar with the concept of cooperative procurement, whether that relates to our cooperative or to the use of other cooperatives. And we'll talk a little bit more about what that means, but this is very much intended to give a broad framework understanding and view of cooperative procurement, or you might hear cooperative purchasing, or you might hear joint procurement, but to give an overview of what this looks like. I think before we get started, Brice, you're gonna do a little informal poll here.
Yeah, we just want to do an informal poll to see sort of what type of experience you guys might have or knowledge you guys might have about cooperative purchasing in general. And so just like Justin said, it'll be an informal poll, so we'll just do it by show of hands. So how many of you have experience with cooperative purchasing? And how many of you have experience running a cooperative in your state? Good number. And how many of you have experience with NASPO Value Point? And how many of you have experience with another cooperative? So good. This looks like about a good even mix.
That's actually much higher numbers than we're expecting. So as we go through this and as we talk through this, please, we're going to try to keep this conversational between the three of us. And we would ask that we have folks ready with, do we have microphones or catch boxes today? Microphones. I like the idea of throwing things in a room full of attorneys, but no throwing the microphones, I guess. If you have a question, just raise your hand and someone will come to you with a microphone so that everybody can hear you. So talk a little bit about what is cooperative purchasing, and I'm not going to read through the definitions here, but this is really two or more governments or governmental units, however we want to define that, conducting a procurement together, right? Fairly simple, straightforward definition. And it's used at all levels of government. Actually, I'm going to go back here for a second. We're going to come and we're going to talk about some of the different uses at all levels of government, but I may want to come back to the conversation of, or the poll question of how many people use cooperatives after we define a little bit of what a cooperative is. So whenever I begin talking about a cooperative, particularly in rooms full of attorneys, but even in not, someone will always ask the question about antitrust. Now, I was going to talk a little bit about antitrust, but we have antitrust specialists, an expert in the room. I don't know if he's in the room right now or not seeing him. But some of the simple concepts behind the idea of cooperative procurement that we talk about at a very basic level is that cooperatives should be optional, right? There's no mandatory use, and they should be non-exclusive. And so allowing some freedom in that, in addition to some of the processes involved, of course, in negotiating the contracts and making sure that we have no collusion. With that said, how many of you have seen this framework before on cooperative purchasing models? It's sort of a common framework, and that's actually so common I wasn't sure who to give attribution to, because it's hard to tell where this came from first. But we've got third-party aggregators, we have piggybacking. I think everyone probably knows what piggybacking is, though some people may disagree on that definition. Then we talk about formal cooperatives. So, let's talk through these a little bit, and I'll take the first one, and then maybe I'll turn Brice and Faye to you to talk about piggybacking and formal cooperatives. The third-party aggregator is sort of a unique one. In some ways, to me, this is a variation of piggybacking, but we have these groups that are out there that create sort of a marketplace of available cooperative contract opportunities, and then advertise and solicit for their use using piggyback agreements. So you think about this as sort of a third party, someone not engaged in the contracting process who is aware of these contracts and then brings them forward and gets a sort of a fee associated with that. The challenges with this one, and we're not going to spend a lot of time talking about it, but the challenges with these often are we don't know if they've been competitively solicited. There tends to be less transparency with this type of cooperative coming forward. Who wants to talk about piggybacking contracts?
I'm happy to take it on. So piggybacking contracts, they don't involve a group coming together and deciding that they all have the same need and then issuing a solicitation together. It's really where one institution issues a solicitation and then will usually include some language but doesn't identify specific purchasers off of that contract. It just says this contract is available for use by all other agencies, or it'll identify a group of agencies. We would see them in Virginia fairly frequently in higher ed, where they would identify other institutions of higher education were eligible to purchase off of their contract. And then once it's into place with that single entity, other entities can end up either issuing POs off of it or taking the pricing and putting it into their own contract. And so there's a couple of different ways that piggybacking comes about, which is why Justin said some of us may disagree on what the definition of piggybacking is, because it looks different state to state and how it's done and institution to institution. But it really is just one entity solicits the contract and then opens the door for other entities to purchase off of it.
And I'll give an example of piggybacking that's a little bit even more obvious, because sometimes, again, that question of advertising, right, and who's going to participate and what have you, raises questions and we don't always agree as to whether something is piggybacking. A very overt example I'll take from my own experience in the Minnesota procurement office. We did a procurement for our Department of Corrections. They outsourced their medical services. It's a unique arrangement. They have nurses that are employees, but the medical and the healthcare program is outsourced. And so that contract was in place. Well, the largest county, Hennepin County, which is Minneapolis, they reached out to me and said, hey, we saw that the Department of Corrections just put this contract in place. We'd like to use it too. And the reason they wanted to use it is because, unfortunately, that is the biggest draw for our correctional system coming from our biggest city. And people go back and forth between the state correctional system and the county's jail system. And so they wanted to be able to have continuity of healthcare records as they move people back and forth as somewhat of a, again, continuity of service, but also as a cost-saving measure. The contract that was put in place by the Department of Corrections did not contemplate, did not consider, did not mention in even the slightest way. I mean, there was no language that could allow us to interpret that this was permissible. But at the end of the day, coming from the state, I said, well, I can't tell you you can or you can't piggyback off of it. You're not allowed to use our contract per se, but if you're allowed to move forward based on our solicitation, based on your rules, I can't stop you either. Okay? Maybe that's not the answer you all would have provided. We can talk about that offline. But they were looking to piggyback off of that contract. Okay? Ultimately, they did a competition and didn't go that direction because of the guidance we gave them on things not being contemplated. But that was a classic example of them seeking to piggyback. Okay? Here's one we don't always talk about with piggybacking, right? Mm-hmm. How many of you use GSA schedules? How many of you like using GSA schedules? They have good definitions, right? All right, sorry, I'm picking on Angela. I shouldn't do that. But the GSA schedules, right, they're easy. But does the federal government really contemplate the state of California's use when they put together their contracts? Don't answer that, right? We might be recording, I don't know. But I would actually look at GSA as a piggybacking arrangement. Now, what's unique about the piggybacking arrangement with the GSA? Anybody? It's probably called out in your statutes, right? GSA is one of those unique piggybacking arrangements where use is typically permissible in the contract. Or I'm sorry, in statute, right? That allows you to move forward. But I would consider it, and maybe not everyone else would, right? Based on definitions, I would consider that piggybacking. Faye, will you talk a little bit about sort of formal cooperatives?
I would be glad to, and I am really glad that my colleagues tackled piggybacking, because in the state that I come from, it was kind of like a bad word, right? Piggybacking, not allowed. So much more familiar with the concept of the formal cooperative. So this includes public sector organizations that work together in a collaborative manner from inception of the solicitation, development, through evaluation and award. These contracts that are established can result in definite quantity, which, maybe on a smaller scale is more realistic, but or indefinite quantity contracts. And we'll talk a little bit too about kind of the drawbacks of the uncertainties around even a formal cooperative contract, even though it's a more collaborative effort. But as you can see, different from a piggybacking arrangement, where it's one entity moving forward with a solicitation meeting its needs, and then an entity later being able to use that contract versus a collaborative effort from the beginning.
All right, thank you, Faye. And again, one example of the formal cooperative is the cooperative through NASPO. And again, we're not plugging for that, but just to use, for example, the NASPO value point model, which engages the states and engages folks from other states to work on the multi-state sourcing team to help draft the solicitation, to advertise, to go through the whole process, to work together to put in place an agreement that then other states can work from in order to use that agreement. There are a few other, though, formal cooperatives here that we don't always think of as cooperatives. And I had a conversation with Keith back there, Keith McCook, who everybody knows by now. I see him nodding. And he raised something to me this last week while we were chatting, which is state term contracts are really formal cooperatives. And I hadn't really thought about it in that context, right? But how many of you, do you understand state term contracts, right? Think of it's a term that many states use, but not all. These are mandatory use contracts within the states that other agencies need to use and potentially political subdivisions need to use. And so those are put in place often not just for the state's use, sometimes not at all for the state's use, but for use by other governmental entities, and so very much then formal cooperatives. There are state-run cooperatives. How many states run their own cooperatives? Okay. Let me ask you a question. Why do you run your own cooperatives? Anyone want to answer that? Yes, sir.
We generate fees from use by other entities, local governments that use it, or
Okay.
higher education that use it.
I'm going to repeat his answer because it's okay. Thank you, Megan. They use the state-run cooperative to raise fees, right, that then support the procurement office.
Also, we're really great at procurement.
And you're really great at procurement. That second comment was obvious, right? Everyone can just assume that at the end of their statement, whatever they may add. Please.
We do the same thing. We do the same thing. We also charge a 1% administration fee, but we also find that we have a little bit more negotiating power if we can team up with a couple states, particularly for the IT contracts.
Yeah, and we'll talk about those benefits, right? The aggregation of spend, right, also gives a benefit to the states, the funding. There are a lot of states that provide significant. I won't ask how many of you are underfunded by your general fund because everyone will just raise their hand, right? But some states are able to subsidize that as well through state-run cooperatives. Yes, sir.
On some of ours, it's because the vendor pool or the business pool is the same in like local state area. So if we in the state of Washington ran a procurement, the same bidder pool would apply to Oregon, Idaho, and sometimes Alaska, right, but then wouldn't apply elsewhere. So it sort of makes sense in that regional approach, especially with like transportation, it matches our FTA area. And that generates that and goodwill between us as partner agencies.
So in addition to aggregating the spend, you can save basically effort, right? And that's really, we're going to talk about that later as well, just a little bit. That's also one of the benefits of entering into cooperative agreements. It's fantastic. All right. So now with this, let's do one more poll.
Sure. Okay, by a show of hands, how many of your states allow use of third-party aggregators? So those entities who make other entities contracts.
Do you have an example of those that I can maybe wrap my head around?
I want to be a little bit careful using an example of those. One of the interesting ones, are we recording? I think we are recording this, but we'll cut this part out. One of the more interesting ones lately coming forward, I think that we may put in that category of third-party aggregators is the Amazon business agreements, right? Or business accounts that are being set up. Now, I'm not sure that's really what's meant by third-party aggregator, but somebody who's coming forward and offering a marketplace of other available contracts, that might fit that definition. And we don't know when we make those purchases as to whether anything was competitively solicited or not, okay? There's one other large cooperative that I can think of that is a privately owned cooperative that, as much as they do some piggybacking and perhaps one could argue some entree into formal cooperatives, does a bit of third-party aggregation as well. If you know who I'm talking about, you know who I'm talking about, but I don't know if that is, I think that's part of the model.
Okay.
Fair enough?
I know who you're talking.
Fair enough, all right.
All right, about how many of your states use piggybacking or allow for use of piggybacking? So more, okay. Question, how many of your statutes actually prohibit piggybacking? Anyone? Okay, well, that's my state there, so. How about allowing use of GSA schedules? All right. Limited, okay. And Blake, that's limited by substantial compliance with the state procurement requirements?
Well, it's even more explicit in our code that in our code there's a specific exception for Division of Forestry and Land to use firefighting GSA
Okay.
stuff. So very narrow. And then yes, the procurement official, the CPO, can make an exception to sign on to a GSA schedule if it substantially complies to our code, which it never does, but still gets approved sometimes.
Can I go off script with another question?
I'm not the one to ask if you can go off script. Just feel free.
So those of you who do not use GSA schedules, why not?
From what I've been told by our CPOs and stuff, they're not really going to substantially comply with our code. They're not really competitively bid the way we would competitively bid stuff. So that's the main reason that I've been told.
Anyone else? Okay. And how many of your states allow for use of formal cooperatives?
Are there
Quite
any
a few.
restrictions? I'm just curious. Are there any restrictions on the use of formal cooperatives? I think we have a couple of hands.
Ours have to be posted in our own state posting system, so even if it's fully competitive, if it's not posted in our state solicitation posting system, we can't use it, and that's in statute a hard limit.
And in Virginia actually has to be named in the solicitation as a potential purchaser off of the contract in order for it to be able to utilize a formal contract.
Interesting. So how many need to be named to use a formal cooperative in the solicitation?
How many need to advertise, at least? So more of you, okay, interesting. I feel like that's not a really uncommon requirement to at least have to advertise those types of solicitations in your state, so that makes sense.
But I think the vast majority, it seems like, do not have to advertise, do not have to participate. They still have the ability to use. Is that correct?
We would require you to file our statewide contracts first, and then we service on statewide contracts and you wanted to do a cooperative, you would then have to come to our agency for permission to do that cooperative. And then the cooperative would have to specifically name the entities that actually could use that, that contract. It can't be, our agency is the only agency that's allowed to use language that says the stuff like all eligible entities and then define that later.
Interesting.
So in South Carolina, we have language that is, I think, right out of the model code, which I think is designed to say you cannot join a cooperative purchase to avoid the rules of competitive requirements in the procurement code. And even NASPO, I could argue, we're hard pressed to find where y'all have satisfied our laws exactly. So we adopted the model code changes, which I think are similar to the guy who was talking earlier. Our CPO has to make a finding of substantial similarity in the process and has some discretion there. When we want to join one like the fire, who was it, the fire suppression, whoever mentioned that one, we get an exemption from the code entirely, and we get it for a really narrow, specific project like that. And they say, we'll authorize this agency outside the code to use that contract.
Okay. Interesting. Anybody else?
So, and we have something a little different. I think you would consider these formal cooperatives, but we have a couple consortiums that by statute we are required to participate in. For example, tax arrangements with other states where the consortium has acquired a software vendor to develop the allocation of tax collections.
Okay. And what state, I'm sorry?
South Dakota.
South Dakota. Thank you.
If I can just ask one more follow-up question, because I think a distinction was made in one of the earlier responses between the Central Procurement Office's ability to participate in cooperative contracting and then other entities within your state. Are there any other states who make that distinction and limit the ability to contract cooperatively to the Central Procurement Office? Okay.
I've got a question for you guys. Megan, here.
Please.
Here. Has anyone else seen private cooperatives advertise in their state with their state's name on the cover of the contract, even though the state had nothing to do with the procurement, and the procurement has been done under another state's law? I hope I used the right inflection for that question.
Say that all. Can you say that one more time?
Absolutely. Has anyone else seen private cooperatives advertise in their state with their state's name on the cover of the contract, even though they have had nothing to do with the procurement and the procurement was done under another state's law?
Wow. Any takers on that? We routinely, or I routinely see some other private cooperatives that will advertise solicitations in other states trying to meet your advertising requirements, even though you may not be involved in that advertising, right? Not within your systems, there they can't get access to, but for those that it's permissible, will advertise in some sort of a journal, right, or a publication of record, so that later they can come back and they can try to market their resulting contract in your state. But I haven't seen the example that was raised by your question. Anybody want to comment on that at all?
I can provide historical examples.
Okay, please.
Nevada. I'm not sure. There it goes. Nevada's law changed fairly recently with regard to cooperatives in 2019. And so prior to 2019, we had a requirement that it had to be advertised in a Nevada newspaper in order for us to be able to join. And after the cooperative law got more broad in 2019, thanks to previous administrator Kevin Doty, we no longer had that advertising requirement. But back when we did see cooperatives advertise in Nevada specifically so that our local government agencies could potentially join it, even if they didn't plan to originally. Since that has changed, I don't know if they still do it because I've stopped checking, but we used to, as a matter of course, advertise in our newspaper every solicitation that NASPO released, even if we hadn't signed a intent to participate, so that if at a later date we wanted to, we could.
Yeah.
But since the law changed, we stopped doing that because nobody actually reads the newspaper to get procurement advertisements.
That's the only reason I read the newspaper. You know, uniquely enough, there's a cooperative. We're going off script here, but there's a cooperative that runs out of Canada for anybody that is interested in Canadian procurement, and I'm sure that's a large group. But there's a cooperative that runs in Canada, and based on the laws at a very basic level, for a local entity to be able to use a cooperative, they have to be named as a potential user in the solicitation. So this cooperative spent time compiling an entire compendium of every local government, you know, all the way up to, you know, the corners of the Yukon, so to speak, and they published that with every solicitation. And they believe that then allows use by local entities because they were named in those publications. So very, very sort of interesting approaches to the publication and advertisement requirements.
And for any of those of you who have read our value point solicitations recently, that will explain why we have listed each of the Canadian territories rather than just making a general reference. So there you go.
All right. So we wanted to talk a little bit through some of the statutory pieces. I spent quite some time in Minnesota's procurement office. I don't know if Luke is in here or not. If he is, he'll probably correct me on something. Thank you, Luke. I thought you'd probably skip my session, but I'm glad you're here. So the Minnesota statute references joint exercise of powers. I think this is very simple. But this is a pretty broad cooperative procurement statute, which is actually how I was able to get my experience because of Minnesota's involvement in cooperatives. 2 or more governmental bodies, right, may jointly or cooperatively exercise any power common to the contracting parties or any similar powers. I'm not sure it gets more broad than that. And you can say, well, where's really the rest of the statute and what else does it say? This is really the crux of what gives that level of authority. And we're going to come back here in a minute. I believe I included the Model Procurement Code piece in here as well, but I just want to talk through and give a few examples. And feel free to say, this is similar to mine, this is very different than mine, and join us in the conversation. Here's the Utah statute. Hopefully I got it right.
Yes. Yeah, so as Blake mentioned earlier, and compared to the statute that Justin just went over, we have a more limited cooperative contracting provision in Utah. You'll notice right off the bat, it's the chief procurement officer who can enter into cooperative agreements with another state, a cooperative purchasing organization, or another public entity within or outside of the state. But this sort of presupposes as well that it's a collaborative effort. Blake, you'll correct me if I'm wrong, and that's since expanded a little bit or changed. But at least when I was there, it was pretty limited to efforts that we had actually kind of signed on to and, you know, had some participation or at least the opportunity to provide feedback on.
Okay. Brice, how about Virginia?
And so Virginia, like I mentioned earlier, they take the position that they have to be named in the cooperative document, and that comes from our statute where it says that a public body may participate in, sponsor, conduct, or administer a joint procurement agreement on behalf of or in conjunction with one or more public bodies. And it may be open to interpretation, but at some point in history before my time with the Virginia AG's office, our AAG that represented the Department of General Services gave the advice that participate in means be at the very least named in the procurement as a potential user. And so that has interesting effects throughout the state as well, because it has the effect of limiting purchases off of other state contracts if the entities were not named as potential purchasers off of it. So I gave the institutions of higher education example earlier, and I had an instance where the Department of Transportation wanted to purchase some parking lot management services off of an institution of higher education's cooperative procurement. But because the institution of higher education's procurement stated only other institutions of higher education can use it, I had to give my client advice, which was not particularly well received, that they then had to go out and solicit their own parking lot management services because they couldn't purchase off of the one that was already in existence.
Yes, sir.
For that purpose, is the executive branch one agency, or is each department its own?
So in Virginia, a procurement authority is vested in the Department of General Services, the Department of Transportation, and VITA, our IT agency. And so while each agency can conduct its own procurements, the rules and regulations are passed down from, the rules and regulations are passed down from DGS and VITA, and then VDOT, because they are such a large agency with such a huge purchasing budget, they follow the rules, but they also get a few of their own exceptions.
So as we were going through some of these statutes, is McCall here? Hi, McCall, thank you. I told you I was going to pick on you before I started. You don't have to say anything, but I'm hoping I got the right updated statute, because as we were talking earlier, McCall reminded me that they just updated their statutes. This isn't updated? All right. McCall, would you tell us what's changed? I'm putting you on the spot because of my mistake. I apologize.
The wording's changed to remove the nonprofit aspect, but it's also, Autumn, do you have it up by chance? Do you want me to pull it up? Yeah.
Oh, no, that's okay. I didn't want to go in there. I pulled it up because as we were going through, you and I have had a lot of conversation over time at the changes, and I found Georgia's to be a little bit different, but I don't want to put you on the spot any further. I'm going to apologize and move on. Okay? And if you want to come back and, you're ready? Okay.
Yeah. So it now reads, no, that's not it.
Moving on. So I'm sorry, McCall, my apologies. But I think Georgia's authorizing statute for cooperatives is a bit different than some of the other states, and we can certainly find another opportunity to talk about that. We also put in here the model, a segment, this is just a portion of the model procurement code, and this is from the 2000 edition of the procurement code, just to give a little bit of an idea of the authorization here for cooperative purchasing, and what came out of that work group is sort of the recommended language. You'll notice the recommended language here doesn't mirror any of the language that you saw from the previous examples, but there are states that have taken the ABA model code and modified it. And I don't know, is this familiar to anyone else in this room as far as being similar to your codes? I know, Keith, you talked earlier, right? South Carolina took the model code, then modified it a bit, I think to allow a little bit broader use, right, of cooperatives than the language is here. This language is, fairly limited in what's allowed, but sets forward some fairly broad interpretation for what cooperative purchasing may be. Now, if you go into the regulations that go along with this, it provides some additional clarity, and that's always worth looking at as a guidance if you have questions about your own statutes, if they're closely aligned to the model procurement code, and even in some cases when they're not. Brice, will you walk us through some of the benefits of the cooperative, just in general, of using cooperative procurement?
Yeah, absolutely. So one of the first benefits is, and the first bullet point is really to address some of the things that the states are seeing that they can ease by virtue of utilizing cooperative purchasing, which is we're seeing across the board increased workloads, more work for fewer people, budget reductions from the state legislatures, and just declining resources in general. And so cooperative purchasing can reduce your administrative costs and efforts because you're pooling your resources with other entities to be able to put together a solicitation that meets the needs of your entities. And then we're also seeing more complex purchasing requirements and varied expertise. And so it used to be that if you were purchasing something like simple roadway construction, it's fairly straightforward. But nowadays, and I often joke that it seems like you can't buy a pencil anymore without having an IT component to it. It seems like IT components are being worked into almost every contract, and not everyone who works at your Department of General Services, your central procurement office, is an IT expert. And so it helps pool the resources of knowledge base to be able to put together the requirements that are necessary for each individual purchase. And it also brings about an aggregated spend piece, which is the ability to use that in your negotiations to decrease prices. If a vendor knows that they're going to be selling to 50 states as opposed to one entity in one state, ideally, they will bring their prices down because they've now got economies of scale built into the contract that allow them to expand their access across more than just one state. And the volume of purchasing power goes along with that, in that when you're increasing the volume, hopefully the prices are coming down. And then it's the ability to promote social objectives, which is really just some of the things that we're seeing from the policy level coming down into the procurement offices, and being able to combine those, because they're fairly similar across many states, being able to combine those and promote those policy objectives.
You know, I'm gonna make two comments on this for a moment. So on my desk, or at my bookshelf at home, I have a publication that was done by NASPO in the 1970s. So as you can imagine, it's very current, right? But it says some interesting things, and this predates NASPO Value Point. This predates this predates WISCA, this predates NASPO's venture into cooperatives, and really the state venture into cooperatives. And it says something really interesting in it. And that is the recommendation that if states choose to do cooperative contracts, large states should lead those solicitations. Because they were looking at the fact, you know, I can pick on a couple people. Angela, I think you probably, the state of California, has a greater ability to negotiate pricing, right, and discounts and terms than Peter, if you're in here, than Delaware has the ability to do, right? It is disproportionate as far as that buying power. And so that becomes interesting. But again, we aggregate some of this together, and the idea, frankly, is that Delaware may get the opportunity to take advantage of California's participation. And that's one of the benefits to folks. This last one, ability to promote social objectives, how many of you think it's actually the opposite? Thank you. Right? So we can talk about this. We have a solicitation that's an evaluation right now for electric vehicle charging stations. That's helping to promote a social objective. But what's the problem with cooperatives as it relates to social objectives within your state?
There's somebody else's objectives?
All right, well, there's somebody else's objectives. That's not where I was going with it, but that's a fair point. What else? Aren't your objectives often focused on your own local suppliers, right? Often focused on women-owned businesses, veteran-owned businesses, minority-owned businesses. And does participation in the cooperative allow you to reach those social objectives if you have those in your state? Or does it potentially prohibit or impact that if the contract isn't established properly? And so that's part of the difficulty, right? If we move away from the more local suppliers to the larger national suppliers, that may have a negative impact on those social objectives.
Justin, I have a question.
Yes.
From the audience. Does your state allow cooperatives for consulting contracts, or are you restricted to commodities and other services?
So I think let's do that broadly to the other, right? Our consulting, how many of you, your states permit use of cooperatives for consulting contracts or work? Okay. So a little bit better than half. Okay. Does that answer the question for folks? Okay. It's always interesting, right? Because it's sort of like 80% of everything we do, everybody in this room is the same, but it's that 20 remaining percent that gets real interesting, right, as to where some of those differences are. Okay? All right. So there are also a number of uncertainties, and let's just focus on one. I'm just kind of watching the clock, and we're having good conversation here. So at the federal government, the term IDIQ, right? Indefinite delivery, indefinite quantity contracts. So we put out a solicitation, here's who's all gonna be involved. We don't know how much we're gonna buy, we don't know when we're gonna buy it, we don't know what we're gonna buy. So in a cooperative, you try to provide some notion of volume, ideally past volume, what's been done in the past, what that purchasing volume has been, what products have been purchased. But do we really know? Do we really have any commitment? And that's sort of a challenge, right? So I'm going to talk about that a little bit here in just a moment, sort of on another issue. But are there any other uncertainties, Brice, Faye, that you want to talk about here?
Yeah, there's definitely some challenges associated with cooperative contracting. The unknowns certainly are one of those. I feel like at a state level, within your state, some of you mentioned you run your own cooperative contracts. It's probably a little bit easier to identify what your in-state needs are, even if it's for a number of agencies. You have a good grasp of the potential usage of the contract, what specific projects may be going on that you can target through your solicitation. And it's really challenging to do that at a national or even regional level. And so like Justin said, you're putting out a solicitation to your vendor community that has limited information. You're expecting them to respond in a meaningful way to somewhat ambiguous specifications, since you aren't quite sure what each participant is going to need. And then you're going to ask them to promise, right, we learned that earlier, promise to meet those needs, even though at this time they're not exactly defined. So certainly the uncertainties and the unknown make contracting at a regional or national level more challenging.
And just sort of piggybacking off of that, it's not just...
Was that a pod, Brice?
It was.
Okay.
It's not just the uncertainties of the need, but it's also the uncertainty from the vendor side in terms of negotiating, because you're essentially asking a vendor to negotiate a contract in specific terms to that contract, which at the end of the day, a contract being a vehicle of risk allocation, without those knowns on the other end of the equation, it's difficult for the vendors to evaluate their own risk. And so they will negotiate sometimes more aggressively, thinking because they have over-evaluated the risk. And so that's another difficulty that we'll run into on the national scale. And I think we have a question.
I don't know if it's a question as much as a comment on a couple of things that were said, because it sparked some interest for me as being a procurement person, not an attorney. Some of the times that we rarely use cooperative contracts, we bid it and allow them, because there might be 15 different cooperatives that can bid on one contract with Granger or with Fisher Scientific. So we allow them to pick which one they want to bid for our needs. One of the things we find in some instances is we can do better as one institution than the whole cooperative can do. An example would be our copier contract. Our local Iowa copier can't compete in California, New York, Minnesota, and that, but they can locally. And so their pricing and service might be better and less costly because we're a known entity to them. They know where we're at. They know exactly how many copiers we have, how to get into and out of each building. Somebody bidding on a nationwide contract has no idea how to deal with Iowa State University. The other piece is that when I'm bidding as a supplier a contract for the entire country, I have to take into account the cost structure for New York and California, which I guarantee, no offense to anybody from those areas, more expensive than Iowa, So their cost structure's got to cover every entity in the entire United States. Well, that may not be beneficial for me in the Midwest. So we always take it with a grain of salt, whether we're going to use a cooperative contract or do a bid and let them offer whatever cooperative they want and let the best cooperative win.
I don't think that's an unfair statement. That's an issue that comes up from time to time, and part of that depends, I think, on the marketplace, depends on the product. I would agree, a cooperative is not always the least expensive. I think you sometimes have to compare terms and what have you. But sometimes in the context of a national cooperative, they're also going to built-in costs for everybody. And I think that's what you were alluding to, right? And you may come from a state or a location where those costs would not be added based on where you are, based on what the market is. Now that's another reason we're going to talk through, and I jumping ahead a little bit, I'm going to talk through in just a moment the need for some second-tier competition when it comes to the use of cooperatives as well, because cooperatives have a tendency to place the price at sort of the ceiling level, right? It's the most they're allowed to charge, but there's always the ability for others to come back and negotiate based on the volume, based on the location, based on the delivery terms, or whatever else may be there. But that's not always how suppliers, when they're bidding through a cooperative, they will often provide that highest pricing. They don't get into the discount, and then sometimes they assume there's going to be negotiation, and then oftentimes there isn't. And so we'll come back and we'll talk a little bit more about that in just a moment. But thank you for that comment. I think that's worthwhile. I won't spend much time on this one. I think we talked about this a little bit in the beginning. Excuse me. But cooperatives are funded based on administrative fees, right? So the cooperative charges a fee for helping to manage, run, administer, whatever words we want to use, those cooperatives. And there's always the question on the impact on price. And I'm going to throw one out on the impact of state decision making. And let's talk about both of those. So admin fees can range, I think, with most of the cooperatives I've seen, from anywhere from 0.1% or 0.25% up to sometimes 2 or 3%. I think I've seen as high as 6%. And then some states throw their own administrative fee on top of any administrative fee charged by the cooperative. So, for example, who do we have here from the state of Florida? Right? Can I pick on you or not pick on you, but can I ask you? Well, he's used to it, right? 1% My Florida Marketplace, right? Fee goes on top of anything, even if it's purchased from a cooperative. So then whatever that cooperative fee is, then it's additional 1% that gets added on top of that gets passed on to the agency or the political subdivision. And again, I think that's a funding mechanism. I presume that's a funding mechanism, right, that's in place.
I'll just talk loud. Yeah, we get the 1% transaction fee, which our legislature routinely reduces to 0.7 as a gift to the state of Florida.
That's very magnanimous.
Yeah, it is.
Yeah.
But yes, we're 100% funded. So the Division of State Purchasing and all purchasing oversight throughout the state is 100% funded by that transaction fee.
Right. So the administrative fees, thank you for that. I appreciate that. The administrative fees give that funding, but the question is, what's the impact on price, and how is that considered when putting together cooperative agreements? And Faye, Brice, I don't know if you want to comment on that at all, or if anybody else wants to comment.
Yeah, I do think the vendor community factors that into the pricing that they ultimately give to the cooperative. But on the customer end, that's also factored into what you mentioned, Justin, decision making. We have a lot of rural communities in Utah that simply don't have the resources to run their own solicitations. So 1% admin fee or adjustment to a cooperative contract, the benefit of being able to participate in a contract that was solicited, put together, evaluated, awarded, administered, and managed by the Central Purchasing Division, the benefit of that just far outweighs the administrative fee adjustment.
That's right. And I think if you talk about, I think that's a really good point from the local government unit as well. I just want to make sure everybody understands that in practice, the administrative fee gets paid directly by the supplier, right, to whoever's running the cooperative or the state that has the fee. But we know that they're passing that cost along. So when trying to decide whether to use a cooperative, you have to consider, right? The total cost, but what's presented to you as the state is the total cost that includes that admin fee. There should not be an allowance for that over and above, right? It should be baked into whatever price so that you can do an adequate comparison and not be outside of that. Now, the second question that's here is the impact on state decision making. And this is a little bit controversial, but does the ability to collect an admin fee for states that run their own cooperatives or add their own administrative fee influence the decision on which contract to use? And whether you might permit another governmental unit, for example, to use a cooperative versus using a state-run contract, or whether a state may choose to use a contract that allows them to collect a fee versus one that might not. And so you don't have to answer those questions. I don't think anybody wants to answer those questions in here today, but it's something that I just want to raise as something a little bit thought-provoking as to what impact or what effect that may have on decision-making at the state level. Go ahead. No, please.
But before we ran out of time, I was hoping you were going to get to the secondary competition. Are you planning to get there?
I'm working on it, Keith.
All right, well, I feel like one thing, you've talked about the benefits, but I think one of the things that really has to be remembered is one of the reasons we have a mandatory process of competition is so the governor and the elected officials and the administrators who prefer a particular product can't just say, we're going with that vendor. But when you have a multiple award menu of vendors on your cooperative contract and you do not require secondary competition, I get to pick whomever I want. So if there are 10 cooperatives out there and the vendor that the governor's getting campaign contributions is on one of them, he can instruct his staff, go use that particular cooperative and pick that contractor, and they've completely complied with the law, except they've avoided every form of control designed to keep the process honest, which is the whole reason we have procurement codes to begin with. And as much as I am nobody could be a bigger supporter of NASPO, and I don't use them all the time, so I don't even know how you structure them. So I could easily be talking about my in-state cooperatives as much as any other state's cooperatives. But it's a question when we explore as lawyers the intersection of policy and cooperative purchasing, are we setting them up to undermine the reasons we require competition or not? Because there are enormous benefits, but with those benefits, I think we ought to keep track of the downsides. And I think one of the solutions is what you started to talk about, which is the secondary competition. Thanks for your tolerance.
Yeah, and thank you, Keith. That was a great introduction to the very next slide. So let me get there, but let's do it this way. Brice, why do states use cooperatives?
Because it's easy to use. Oftentimes there's a vendor on there that they've been using for a long time, and to Keith's point, they can directly select the vendor. And obviously the goals of hoping to get better pricing, and to Faye's point, that they may not have the resources to conduct their own solicitation, so they will hop onto the cooperative to make sure that they're able to still get those services, and there's a benefit to that.
Right. So how many states in here, if you can go to a cooperative, can just go in and let's say there are 6 different suppliers on the list for that cooperative, how many of you can just pick the one you want to use? How many of you that can pick the ones you want to use typically just pick the ones you want to use? Okay. Why? I mean, listen, everyone in procurement has plenty of time, right? So if there's an easy way, nobody's going to take it, right? We know that's not the case. And so I think what Keith is alluding to here often is, to what extent does the ability, and I'm not going to talk about the political influence or anything else, right? We all know that we have certain pressures that are there, but the ease of use. If we have an ability to go and pick a supplier versus having to go through a whole competitive process, and you've got how many other procurements going on at the same time, how many other requests, what are we trying to get through that day, what are you likely to do? Take that path of least resistance, right? We know the supplier, we've worked with them before, the cooperative met our requirements for advertising, for fair competition, and so on. So we're just going to go to that supplier, we're going to write a work order, we're going to write a bid, whatever, a PO, whatever it's going to be, and we're going to move forward. But this idea of second round or second tier competition really is something that, we have up here increased competition and better pricing, but I think it also serves to better protect procurement, to better preserve the integrity of procurement, and to get better overall results. Just by going out to 2 or 3 of those 6 and saying, hey, give me your best price, right? Even if it's nothing more than that, even if it's not formal, but just going out, let's say, and getting 3 quotes from those 6 that are on the cooperative, add some integrity, add some additional competition, adds a layer of protection to the process. And I think, Keith, that's what you were aiming at. Is that correct? All right. So I'm going to skip over the keys to success here. Faye, will you do me a favor, just at a high level? Can you talk about some of the legal and contract challenges, particularly those involved in the contracting amongst 50 states and cooperatives? And can you do that in the next minute and 20 seconds?
Yes, okay.
Thank you.
So luckily we touched on this earlier. There are some challenges associated with cooperative contracting, especially at the national level. We see this all the time, right, with the NASPO Value Point Cooperative, as I'm sure other cooperatives do. It's difficult to try to address the needs and be responsive to the needs of 50 states. And so we try to paint with a broad brush, right? Or we have to at that level. And I think that's why it's so important, like Justin said, that we remember it's not an either or when it comes to using a cooperative or having some sort of competitive process within our state. I have seen states do a 3-tier process where, at the participating addendum level, they compete, their state business among the contractors in a portfolio, and then at the order level, they're taking advantage of volume purchasing and competing it again. So there are definitely challenges associated with large-scale cooperative contracting, but there are processes and approaches that serve to mitigate those challenges.
Thank you very much for that, Faye. I'm going to skip, we're going to skip to the end. Let me just do one thing real quick, and then I'll walk through this. If you have questions about the Value Point Cooperative, use of that cooperative, use of other cooperatives, feel free to talk to any of us. And if you're here from the NASPO Value Point team, could I ask you to please stand up so that everybody can see who you are? We have Jamie Shore, who's our Chief Cooperative Procurement Officer, Solomon, Zach, who are 2 of her deputies. Please feel free to reach out to these individuals as well. Thank you for joining us in the conversation.